Good afternoon. My name is Michelle Barker. I'm Senior Legal Counsel here at Medcom, and I will be the speaker today on the ACA, What's Changed. And this is in regards to the Texas case that came out, Texas et al. Versus United States of America, which came out last Friday, and I'm dealing with the ACA. We are recording this presentation, and we will distribute the recording and a copy of the presentation next week to all attendees. There will also be a question and answer time at the end, so please type your questions into the question box, and we'll be sure to answer them all. And again, today's topic is ACA, What's Changed. First off, just a little bit about Medcom. Medcom is a benefit solution company where we have over 35 years of employee benefit administration and consulting services. We were actually founded in 1983. Our home office is in Jacksonville, Florida, and we have a regional office in Atlanta, Georgia. Our portfolio of professional services are kind of massive. We have a division for the ACA, which is the ACA Consulting, Compliance, Reporting, and Penalty Appeal Support. Under consulting, we'll just answer ACA questions. We do the reporting, those lovely 1094s and 1095s. And now that the IRS has started to file appeals and send appeal letters under the 226J, we have been very successful with our clients in getting the penalties either reduced or zeroed out completely. We have a health and welfare compliance division that does everything under ERISA, including VAP plans, non-discrimination testing, and anything that you might have for compliance needs. We also have a HIPAA privacy and security division, which does privacy and security policies and training for self-funded groups. We have Fringe Benefit Administration for COBRA, Fringe Benefit Administration for those lovely consumer-driven health plans, including flex spending accounts, HRAs, and HSAs. And then we also do government health care programs where we actually do government programs and actually look at some claims there. Sorry, we're having a little bit of trouble changing it. This presentation here is intended to be used for informational purposes only and certainly does not provide any legal opinion. And Medcom serves only as an impartial presenter as well. As we know with the ACA and with the government and the whole, things can get a little emotional and a little lopsided, but we try to be an impartial presenter of any information that we send out to on our webinars. So first off, let's get into the actual case itself and the players in Texas et al. Versus the United States. Who are the players? Well, the plaintiffs are the ones that actually filed the lawsuit. And it was several states. It was Alabama, Arizona, Arkansas, Florida, Georgia, Indiana, Kansas, Louisiana, Mississippi. And you see the list there. There were 20 states that actually filed a lawsuit saying the ACA was unconstitutional. And then 2 individuals were also allowed to join in as plaintiffs. The next are the defendants who were defending the lawsuit and saying, no, the ACA is constitutional. Well, as you would expect, it was the United States Department of Health and Human Services, of course, the Internal Revenue Services, and then there were some what we call intervenor defendants, people that came in as defendants that were not the government, and they were actually California, Connecticut, Delaware, Hawaii, Illinois, Kentucky, Vermont, Virginia, Washington, and the District of Columbia. You know, people say, well, that's part of the government, isn't it? They are states. And typically in the law, believe it or not, the feds are considered the government and the states are considered the state. So again, the defendants were basically the Department of Health and Human Services and the IRS and the government entities. and then the judge was Reed O'Connor. Now, there were several laws that came into play with this decision. The first law was Section 5000A, and that is your individual mandate. That is the mandate that says all individuals, with few exceptions, have to have health care coverage or face a penalty. Now, Section 5000B is the individual mandate penalty. It's separate from the individual mandate, but it is the actual penalty for the individual mandate. And basically, that is the mandate of the penalty that was imposed if an individual without a reason not to have insurance or was exempt from having insurance had to pay a penalty for not having that insurance. Then our favorite, of course, is Section 4980HA, whether it's A or B, and that's the employer mandate, which all applicable large employers with 50 or more full-time or full-time equivalent employees must offer coverage or face a penalty. And then we have Section 6055 and 6056. Those are the reporting requirements, the lovely 1095s and 1094s. And 6055 is basically for all providers of insurance must offer coverage. This is your 1095B series and Part 3 of the 1095C if you're a self-funded plan. And then what precipitated all of this, and we cannot exclude, is the Tax Cut and Jobs Act of 2017, where the individual mandate penalty was reduced to 0 under 5000B. It did not get rid of the individual mandate. It only got rid of the mandate penalty. Why? Because it was done under what we call budget reconciliation, and the only thing they could address was the budget. So the budget had the penalty, they got rid of the penalty, but they could not get rid of any of these other sections. So as it stood before the judge made his ruling, 5000A, the individual mandate stood, the 4980H employer mandate stood, as did the reporting requirements. Now, let's go back to the very beginning of the ACA, because this is what the judge ruled, and this is why it's so important to understand how the law works. When the federal government passes a law, they must have authority to do so. And typically the federal government authority comes from one of 3 clauses in the Constitution. The first is the Commerce Clause, and it's Section 1, Article 8, Clause 3, and it gives the Congress the power to regulate commerce with foreign nations and among the 7 states and with the Indian. So in other words, they can regulate commerce, foreign trade, trade between the states, anything that affects that, the government can legislate to. This is probably one of their biggest powers, and in the past, they used it to justify a whole lot of legislation. I'll give you an example of one that really showed just how far-reached this clause could go. In the early 50s, there was basically a law that said that we were putting some restraints on wheat, that individuals had a ration for wheat. You could not buy more than this amount of wheat, and we couldn't sell more than this amount of wheat. It was a wheat ration. And an individual farmer actually went out and he decided he was going to grow wheat for his own personal consumption, and he did. And he was sued because he did that. And he said, it's my land, I should be able to grow what I want for my own personal consumption. It went to the United States Supreme Court, and they said the government had the right to regulate wheat under the Commerce Clause, and that he, by growing wheat on his own farm, violated the law, and therefore the law was constitutional, and he was enjoined from continuing to grow wheat for his own personal consumption. That was a very, very far-reaching case, and one of the cases that they talk about all the time as to, do we want the power to be that driven, or do we want to expand it any further than the wheat farmer? The Necessary and Proper Clause is another clause under the Constitution, Article 1, Section 8, and it gives power the right to make laws which shall be necessary and proper for carrying into execution all the other powers that they have. So the necessary and proper clause usually doesn't stand on its own. They have to be able to address another power and then saying that this is supporting of that power. And the third one is taxation, that Congress shall have the power to lay and collect taxes, duties, impose excises, to pay debts, and provide for the common defense and general welfare. But all duties, imposts, and excises shall be uniform throughout the United States. You cannot put one heavier tariff on one than on the other. Then we had two previous cases under the ACA, and the first one is really, really important. It was the National Federation of Independent Businesses, Ental versus Sebelius, who was the Secretary of the Department of Health and Human Services in 2012 when this lawsuit was filed. And basically what happened under this lawsuit is the ACA was passed and there was a challenge. And the challenge was, under what of those three powers did we talk about, or under what power do you have to regulate and force people to buy insurance in that marketplace? And the government, because of the wheat farmer and every other case that came after it, said, well, of course, it's under our Commerce Clause. Well, in a 5-4 decision, the Supreme Court ruled that they did not have the power under the Commerce Clause to do it, that you couldn't force somebody into the marketplace and then say commerce. So they said while they did not have the right under the Commerce Clause, they did have the right under taxation, so that the IRS was imposing those penalties, and under the individual mandate, you know, the PT, it's basically a pre-tax credit that you're getting in order to purchase the insurance. We call it a subsidy, but it's really a pre-tax credit. And they said, hey, federal government, that's what you have. That's where the power lay. 5-4 decision back in 2012. So what's at stake? Well, basically, when we passed that Tax Cut and Jobs Act in December of 2017, we reduced the individual mandate penalty to 0 under 5000B. The law did not, that Tax Cut and Jobs Act did not replace or repeal the ACA, but it reduced that individual mandate to 0. So the question was for the Texas court was whether the individual mandate, was it still constitutional? No, without that tax, could they still apply the individual mandate and say, we have a mandate out here that you have to buy insurance, but now we don't have a tax on it if you fail to do so? And the second part of the question that the judge had to answer was, if you deem that the individual mandate was not constitutional, what about the rest of the ACA? Could you say that if the rest of the ACA was what we call severed from the individual mandate? Could it stand on its own so that the employer mandate and all the other pieces of the ACA would stand even if the ACA fell apart? So that was basically what the judge had to decide in Texas. And he said, look, I can't find any power under the Commerce Clause because back in 2012, the Supreme Court ruled 5-4 that there was no Commerce Clause power under the Affordable Care Act. And so basically he said we have to rely on the taxation. That's where the power lay. But he said that the Supreme Court had identified 3 factors to determine whether or not there was a tax under 5000A, which is there a payment to the Treasury? There's a payment, is it determined by income or other factors? And the payment produces revenue for the government. Think about this. This is what a tax is, isn't it? When we pay the tax, we pay it to the Treasury. It's based on our income and some other factors, and the payment produces revenue for the government. But now, under the Tax Cut and Jobs Act, 5000B did not do any of those 3 things, let alone one of them. There was no payment to the Treasury. There was no payment determined by income or other factors. And the other factors were whether or not you might have had insurance. And then 3, there was no revenue going to be produced for the IRS. So then the judge said, look, the individual mandate is not constitutional because of that. So then he had to go to look to see whether the rest of the ACA would stand up or not. And the doctrine of severability is rooted in the separation of powers. We have three legislative branches. We have the Congress, we have the judiciary, and we have the executive. The judiciary does not make the laws. All they can do is read it. And he said, you know, I'm reading this, and I can't see that I can keep the rest of the ACA intact because it would change the whole face of the ACA. He had to play a really tight, close look to see whether or not he could sever it. And he said, you know, one of the things we have to do is look to see if we can salvage it. That's our number one job. He said, I tried. But then when I looked at it, I also have to see whether or not it would change the meaning of the ACA if I left the other mandates in place without the individual mandate. And he said, I can't do that. It changes the law. And then he said, do I have evidence that there was not the intent to sever the law? And he said, I found evidence. And where did he find it? He said that they could not show that the legislation would have been enacted without the individual mandate. He said congressional intent, they kept on talking about, the intent was to significantly increase healthcare coverage, lower insurance premiums, improve health insurance products that are guaranteed issue, and ensure the pre-existing conditions were not excluded. In short, near universal coverage. And he said it was a trade-off, wasn't it? He said in the ACA, we were going to trade off pre-existing conditions. There would be guaranteed issue. Everybody would be able to buy the insurance because we would have near universal coverage and there wouldn't be adverse selection. So with the individual mandate being out there forcing individuals, healthy individuals into the marketplace, then we could do the guaranteed issue and we could do the pre-existing conditions. The other thing that the ACA did that we don't talk too much about is it lowered the cost that the government would pay to the hospitals. And it said the hospitals cannot now overcharge. There's a lot of things that the hospitals can't do. But that was a trade-off too, because now the hospitals are going to have people that are covered and they're not going to have to change down those ones that are underinsured. So that the hospitals were giving up something because of the individual mandate. And then on the employer mandate side, is it fair to put all the burden on the employers with no individuals? Because that's going to rise the cost of the insurance company and the premiums too. So is that fair that the employer costs will skyrocket? So he said, I really had a difficult time severing it because it was a trade-off, one for the other. Then he said, when you looked at the actual law, he said on 13 different times, Congress explained how the individual mandate stood as the keystone of the ACA. So he said they even said that this was the keystone. And they didn't say the law was severable. The rest of the ACA was severable. Now, if you remember back at the beginning of the ACA, they also talked about Medicaid expansion. When they talked about Medicaid expansion and they put that in the ACA, they actually said that was severable, so that if the mandate for Medicaid actually fell through the cracks and the court ruled that it wasn't constitutional, as they did in King versus Burwell, he said, we are still saying the rest of the ACA stands. So they could do that with Medicaid because the law said so. But when the judge looked at it, he said, I didn't see anything on the individual mandate saying that this could be deemed unconstitutional and the rest of the Affordable Care Act stand on its own. So he said, no, I can't do that. And then he said, if you look at the two Supreme Court cases, the King case on the Medicaid expansion and the NFIB, where the where the Supreme Court said that it was a tax, he said all 9 justices agreed at one point or another the individual mandate could not be severed from at least the pre-existing condition clause because you needed to have the individuals, healthy individuals enroll before you could get to eliminating pre-existing. And then he also quoted Chief Justice Roberts, who was the instigator of of the NFIB decision. He was one that wrote the opinion and said this is a tax. And he said, even Justice Roberts said that the individual mandate was the fulcrum of which the macro-level trade-offs pivoted. So even Justice Roberts said that you had to have all these trade-offs as a whole in order to make the ACA work. So basically what this judge did was he shot down the whole ACA last Friday, and he said the law was unconstitutional in his opinion based on his logic, and it was a 55-page decision. So when this happened, of course, everybody starts to act and say what they think. Nancy Pelosi came out and she said, look, when the House Democrats take the gavel of the House of Representatives, we are going to move swiftly to formally intervene in the appeals process to uphold the life-saving protections for the people with pre-existing conditions, and we're going to reject the Republicans' efforts to destroy the Affordable Care Act. So she said once they get back in session in January and the House reconvenes, we're going to be at the 116th Congress, we're going to fix this. Donald Trump, on the other hand, said if the Republicans and Democrats get together, we are going to end up with an incredible health care, which is the way it should have been from day one, and it's going to happen. It now has a chance to happen. So let's go back and look at the House of Representatives and what Nancy Pelosi and the Democrats control. The members are elected for a 2-year term, so they're going to be elected for 2018 to 2020. And of course, in 2020, we're going to also be going through the general elections. Again, the full, complete 9-yard, who's going to be the president, et cetera, et cetera. We have 435 seats in the House in the 116th Congress. We're going to have 235 Democrats and 119 Republicans, and we have one vacancy. So if nothing else goes wrong and Nancy gets all the Democrats behind her, they could potentially pass something in the House. They've got a majority. They can, the Democrats alone, pass a law or pass a bill in the House. But then what happens? It has to go to the Senate. And when it goes to the Senate, we've got a different picture. We've got 53 Republicans and 45 Democrats. And we have 2 independents that usually caucus with the Democrats. So the Republicans still have the Senate. So even if it goes through the House, it doesn't necessarily go through the Senate. And then one of the Senate rules is what we call a filibuster rule, that if it's not resolved within a certain time frame or whatever, and it gets filibustered, then in order to pass, you need 60 votes. So the Republicans would not have 60 votes to kill it or to pass their own bill, and the Democrats wouldn't have 60 bills to do it, 60 probably to do what they want. So the Senate is going to be a huge issue moving forward. And then let's not forget the president at the end, because the president can veto. And if he vetoes any act, it takes a 2/3 majority in both houses to go through. Nancy does not have 2/3 of the House. So if the president vetoes, it could kill whatever they're trying to do. So we're in a conundrum right now as to what's going on. Will the Democrats be able to do what they want unilaterally because they control the House? Probably not. What about the Republicans who control the Senate and the White House? We've seen that. Probably not. So the only way that we are going to get any resolution is one of 2 ways. If the 2 parties come together and actually start working together on resolving the issues and how important it is to each of the parties to do so, and the other is the court. This case did not have an injunction put on it. So the law of the land is still the ACA until it works its way up through the other courts. The next stop is the Texas Supreme Court or the Texas Court of Appeals. And then after that, it would go to the Texas Supreme Court and then to the United States Supreme Court. It can take a couple of years. It could take 2 or 3 years. It doesn't look like it will go through the Supreme Court this term, which is from October to June. So it's going to take a while to build up. both parties know they don't have the majority to get the legislation done. And basically, when you read the decision, it's not a slam dunk for either side either. So they're either going to have to work together or rely on the courts. I tell you, I was an ex-public defender. Deals are made before the court decisions reach. Because if you want to make a deal and you don't know what the court's going to do, make it now. And so that's probably going to be something that they're going to have to seriously look at, because right now the courts say it has to work its way up through the appeal process. So what to do in the meantime? Well, we know that the fate of the ACA has been up and down since a yo-yo, but since 2010, it has been the law. Since 2015, we have had the employer mandate, and that did not go away with this decision until it reaches the final court, or until the Republicans and Democrats get together. The ACA has survived each challenge and each change of government, and it could still survive this as well. So it's still the law of the land. We still must make sure that we're doing what we're supposed to. Stay on course. Reporting in 2018, in the 2019 year, the forms that are due now or coming up to be due, it's still a go. This court case wouldn't have even changed it, because the penalty being reduced to 0 didn't go into effect until January of 2019. So the reporting year this year is still a go, and I will lay you bets I still think 2019 will be a go. So go ahead and make sure you stay the course. Don't get too involved in the hype that you might hear. Stay the course until the actual decisions come out. And again, as we say all the time with the ACA, the more things change, the more they remain the same. Nothing has changed, all still the same. Always the hype that the ACA is going away. It still has been the law of the land. It's still the law of the land. Stay the course. So with that, do we have any questions? Is there a new court? Does this mean the ACA needs to be filed this year? Yes. In March, the forms are due by March 4th, because we got that automatic extension for the forms to be given to the employees, and must be filed electronically with the IRS no later than, I believe it is April the 2nd, because March 31st falls on a Saturday or Sunday, so I think it was April the 2nd. But yes, they absolutely still have to be done, absolutely still have to be done on time. So that that's something that still needs to be done. A little thing about the automatic extension we got for the files to be given to the forms to be given to the individuals. The IRS made it clear that's it. You cannot ask for a further extension. March 4th is the drop-down deadline. Don't come to them before March 4th and say, hey, I need an extension. They're not going to give it to you. The March 4th is it. The next steps for the court case appeals process and the time frame. First off, they have to file an appeal. One of the sides has to file the appeal, and I understand the defendants are going to file the appeal, which is the government and the states. Now, I will tell you, the government, the players, the Department of Justice, did not argue the pre-existing conditions or that the individual mandate fell. They just said that they did not argue that the rest of the law would fall. That's why the intervenor states came in as well. They wanted to defend the whole thing, because the government wasn't going to defend the individual mandate of the pre-existing conditions. It now has to go up to the next court in Texas, and once it reaches its highest court, then it will go to the Supreme Court. Typically, this takes quite a bit of time. So both sides get to have the chance to brief the cases, go back to oral arguments, then put it on the docket for the judge to hear. So this could take, if you looked at President Obama came out a couple of days ago, and he said it could take a year or it could take years. And I have a feeling he's right. It could take a couple of years for it to work its way through the court, especially when you're reaching the Supreme Court level. If it reaches the Supreme Court, that typically takes a couple of years. The Supreme Court, they have their year-end session is from the first Monday in October to the end of June. So anything that doesn't reach them or anything they don't hear before that time gets put off to the next session. So it is very unlikely that it will reach this year, and therefore the earliest it would hit would be October of 2019, potentially be decided by June of 2020. By that stage of the game, we'll already be through the 2020 reporting year. So I don't think anything's going to happen this year, potentially not next year. And the only thing that might happen is we might have a trade-off with the Republicans and the Democrats in order to solve the issue. And is there new codes for this year? There's no new codes for this year. There were new codes last year if you offered conditional coverage to the spouse or to the dependents. There were some conditional codes. No new code changes for this year. The only thing you have to make sure, because there was a change, is as far as they have now, because of confusion, separated the first name, then there's a box for the middle initial, and now there's a box for the last name. So you have to make sure your systems are geared to have a box for the first name, a box for the middle initial, and a box for the last name. Because as you know, before it was all under one box, so now you've got to separate those boxes and make sure that your system is geared to separate those boxes for names. But I think that's all the questions we have. And as always with the ACA, I always say stay tuned, because the more things change, the more they remain the same. But we always know that there's always some updates and things happening with the ACA. So stay tuned, but stay on course. And I want to thank you all for your participation today. Thank you. Bye.